Hi, my name is Natalia Willette, and I'm a real estate attorney here in the state of Florida. And today I want to give you an update on the status of stays on residential evictions in the state of Florida and at the federal level. So, this is number one, only affecting residential evictions. There are no stays on commercial evictions in the state of Florida, either at the federal level or at the state level. So, that's number one. Number two, residential evictions. At the federal level, the CARES Act expired, so different agencies provided for an extension of the stays on residential evictions through December 31st of the year 2020. And what does that mean? Well, the FHA, VA, and Fannie and Freddie have all issued a agency-specific stay on residential evictions. These are stays based on non-payment of rent. They are not stays for any other basis. So again, if your tenant is breaching any other of the lease terms, you can evict them. So if they are having animals that are not permitted on the property under the lease agreement, if they are destroying your property, if they are subleasing, or if they've added people to, that live there with them now, they're adults that are not on the lease agreement and that was not permitted under the lease agreement, then you can evict them under federal law. In the state of Florida, we have a very different kind of stay. So the state of Florida used to have a blanket stay on residential mortgage foreclosures and residential evictions. That all changed on July 29th when Governor DeSantis changed the language of the stay. There is no actual stay anymore. People can file residential eviction proceedings, and they can be for non-payment of rent and any other legal basis based on a breach of the lease agreement. The provision now has just created a defense to being evicted out of property if the non-payment of rent relates directly to the COVID pandemic. So that means you as a tenant have had to have lost your job, lost your income, had a significant reduction in hours relating directly to the COVID pandemic in order to have a court refuse to enter a judgment for possession in favor of the landlord. So that is a substantial difference from what it used to be, which was a blanket stay. That was good through the end of September. It was then extended by Governor DeSantis with the exact same language through October 1st. So that is what is in place at the state level in the state of Florida. People, of course, have been asking about the CDC. What about the CDC? What about this guidelines that they issued? Well, in my professional opinion and the professional opinion of a lot of real estate attorneys here in the state of Florida, it's unconstitutional. The CDC doesn't have a lawful basis from which to interfere in evictions at the state level, and that is because the federal government has to have a basis for which they can create regulations, rules. Often they can manage interstate transactions, they can manage transactions from people coming out of the country into the country, but they don't really get to issue proclamations that govern private contracts within the state. That's something that's left to the states. So as far as the CDC guidance goes, I've advised my clients that it's unconstitutional. It's going to be very hard to enforce. And so there you go. There is my update on tenancies, residential tenancies, residential evictions, if you are a landlord or tenant in the state of Florida.